Trinity College law professor Diarmuid Phelan, and he's a senior counsel as well. He has been acquitted by the jury of murder of Keith Conlon for trespassing, or who was trespassing on his farm in January 2022. The jury was given 3 possible verdicts to bring back: 1, acquittal; 2, guilty of murder; 3, not guilty of murder but guilty of manslaughter. The jury, after 7 hours of deliberations, decided to bring back an acquittal, and Diarmuid Phelan is now a free man and walk free from the Central Criminal Court. He was impassive when the verdict was brought back, and the people, Mr. Conlon's family were there as well, and they remained silent when the verdict was brought back. A key thing to understand is that the judge, in directing or instructing the jury, gave the jury a number of questions to answer in their deliberations, and she gave them a document called a route to verdict, an RTV, a route to verdict document. And this document contained a number of questions that they needed to answer. 3 questions, in fact, or at least 3 questions. And the answers to these questions would give a good indication to the jury, to each juror, as to the guilt or otherwise of Mr. Phelan. And having considered the verdict for 7 hours in total, the jury brought in a verdict of acquittal of murder. Yeah, there was 9 men and 3 women on the jury. They deliberated for 4 hours earlier this week and 3 hours today. Mr. Phelan sat impassively when the verdict was given. Mr. Conlon, then, the dead man, he was the father of 4 children. He was shot by Mr. Phelan at the farm, and he was pronounced brain dead at Tala Hospital 2 days later. The court trial heard that Mr. Conlon and two others were on the farm that day. They were trespassing. The 2 dogs, a lurcher and a terrier, and were apparently engaged in badger baiting. After hearing a dog barking for some time, Mr. Phelan went to investigate, and he shot the lurcher with his licensed Winchester rifle. The prosecution contended that led to heated exchanges with the trespassers, and Mr. Conlon and Mr. Coleman followed Mr. Phelan up a field. The prosecution case was that Mr. Phelan then took his licensed Smith & Wesson revolver from his pocket, fired 2 shots into the air, and a third penetrated the body of Mr. Conlon. When the third shot was fired, Mr. Conlon was shot in the back of the head as he turned away, and in the circumstances, according to the prosecution, Mr. Phelan had the necessary intent for murder, the prosecution contended. There was witness evidence then from farm workers. There was a 19-year-old German girl who witnessed the shooting. She said from the beginning to the end of her evidence, she maintained that she saw a man with his back to Mr. Phelan at the time of the fatal shot. It was contended by the prosecution that there was nothing in the encounter with the trespassers that could have led Mr. Phelan to believe he was being presented with such a threat of force to justify producing a revolver from his pocket and to repeatedly fire it. Mr. Phelan then, in interviews with the guard, said that he was frightened for his life. He said he was terrified. He said that if he had not reacted immediately, he would have got me. He said he fired shots in an arc above the heads of the trespassers, and he was stunned when Mr. Conlon fell down. The defence contended that the discharge of the firearm was a legitimate act of self-defence and not done with intent to penetrate the body of Mr. Conlon. Mr. Phelan was facing imminent attack. He was outnumbered by the trespassers who had earlier told him after he shot the dog, "You're fucked and they're going to get him," his counsel Sean Gearan said. The 2 men were within a split second of doing just that. Mr. Phelan had reached for what was at hand, his revolver. He had no time to think, and he fired 3 warning shots. The 3rd hit and killed Mr. Conlon, but he never intended to hit him, counsel Sean Gearan said. He said that it was an unintended killing, only accidental in the sense that some movement of Mr. Conlon or the gun brought a bullet into contact with Mr. Conlon, Sean Gearan said. And evidence then from firearms experts was given and by the defence, which showed that the gun's lightweight, the trigger pressure, repeated firing of it in short sequence, finger placement and movement of Mr. Conlon and Mr. Phelan could all explain change in the anticipated point of impact, Sean Gearan said. Even if the prosecution proved that the 3rd shot was an aimed shot targeted at Mr. Conlon, the use of force in what is described as legitimate defence. Self-defence, as prescribed by law, is a defence to murder and manslaughter, he said. The defence asked the jury to consider also the vulnerability of Mr. Phelan in the context of criminality on his farm over years. He said there was a background of people coming onto his farm, including some who engaged in criminal damage, arson, theft, illegal dumping and drinking and taking drugs, the jury heard. Each juror, when they were going out then to consider the verdict, they were provided by the judge with a written route to verdict document, an RTV, suggesting 4 questions for consideration, the answers to which could lead to one of 3 possible verdicts: acquittal, conviction of murder, or not guilty of murder but guilty of manslaughter. The document set out that the onus of proof is on the prosecution and the standard of proof is beyond a reasonable doubt. And this standard of proof compares or contrasts with the standard in a civil case, which we saw in the Conor McGregor and Nikita Han case. The issues addressed in the route to verdict document included ones concerning whether or not the prosecution had proved that Mr. Phelan had the necessary intent for murder, that is, to kill or cause serious injury. He must have had intended to kill or cause serious injury. If he didn't intend to kill or cause serious injury, then he had to be acquitted. They also had to consider whether or not he honestly believed he had to use force to defend himself. And then they also had to consider the question of whether or not the force that he used was excessive, rendering it unlawful, or was it reasonable, in which case he was acquitted. So there you go, Diarmuid Phelan, acquitted, Trinity law professor, senior counsel, acquitted of the murder of Keith Conlon. Hope you liked the video. Hit the thumbs up button down below if you do. Thanks a lot.